All right, AP Gov, real quick video today. Also, I lied. There is one last court case you guys got to do. So yesterday you did Brown versus Board of Education. You did Roe v. Wade. Today you can look at Gideon versus Wainwright, another civil liberties case, another selective incorporation case, how the Sixth Amendment gets applied to the states, and specifically the Sixth Amendment's right to counsel. So it used to be that if you were accused of a crime and you did not have the money for a lawyer at the state level, you would pretty much have to represent yourself. That's what this guy Gideon, who lived down in Panama City, was accused of robbing a bar, had to represent himself. He went to prison and he wrote a petition of certiorari to the Supreme Court. He hand wrote it. The Supreme Court issued the writ of certiorari, called the case up, and then they applied that right to counsel to the states of the Sixth Amendment. All right, so you're going to go watch that video today. Again, really pretty straightforward. It's a civil liberties. It's a selective incorporation. It is important. So please go do that. Sorry about that. I thought Roe v. Wade and I thought Brown versus Board of Education was the last bit. All right. Tomorrow, I'm going to get into civil rights. I'm going to cover everything civil rights. I'm going to put up a video for the last document, which is MLK's letter from a Birmingham jail. That's going to wrap up the course. I'm then next week going to start doing review videos where I go over like 10 concepts at a time. And you guys can start to digest those, and I'm going to start doing more FRQ review videos as well, okay? I just want to talk about some of this that I talked about in the previous video. So I know I talked about the exclusionary rule. I want you to make sure you got this definition down. So evidence that the government finds or takes in violation of the Fourth Amendment cannot be used against you at a trial. This was later incorporated to the state. So this was later a selective incorporation piece. So the exclusionary rule is talking about the Fourth Amendment, and that part of the Fourth Amendment gets incorporated later to the states. It was a court case called Weeks versus United States. You don't need to write this down. Weeks versus United States. Early 1900s, a guy had been selling lottery tickets through the mail. The federal government had come in and basically busted him without any kind of probable cause or warrant. And that makes its way to the Supreme Court. Supreme Court says, hey, there's this exclusionary rule. So if evidence is obtained against you illegally, it cannot be used against you at trial. Later on in Ohio, there's a case called Mapp versus Ohio. Again, you don't need to write this down. Where a woman had done some wrongdoing. The police just forced themselves into her house, found some evidence of wrongdoing, and tried to prosecute her using it, even though they had never had any kind of probable cause or a warrant. That makes its way to the Supreme Court. Supreme Court says, hey, this applies to the states as well. Okay, so exclusionary rule, Fourth Amendment, there you go. Miranda versus Arizona, it just feels weird not mentioning it. It's something you really had to kind of get into prior to this redesign a couple of years ago. It's a U.S. history standard, so you may be familiar with it from your U.S. history class. Most of the Fifth Amendment gets applied to the states through selective incorporation with the Miranda versus Arizona case. All right, so that whole idea of you have the right to remain silent. Anything you say can be used against you in a court of law. All of that, those rights of the accused that they have to read you at the time of your arrest. That was not the case before Miranda versus Arizona. This guy was mentally challenged, and the what the court basically found was he was kind of forced into this confession. When he didn't know his rights. The Supreme Court takes on this case, and they say that state law enforcement must inform you of your rights, mainly your Fifth Amendment rights. A little bit of the Sixth Amendment as well. So, because that's that last part where they say if you can't afford an attorney, one will be appointed for you. So most of the Fifth Amendment, parts of the Sixth Amendment gets applied to the states through Miranda versus Arizona. Not a required court case, but it's another example of selective incorporation where you're seeing parts of the Bill of Rights apply to the states. For me, it just feels weird not to mention it. So I have every year since the redesign, and it is in the book, and I think you will find it in that Princeton Review book as well. Roe v. Wade, I kind of want to just review that a little bit. He talks in the video about Griswold versus Connecticut, but he doesn't really get into it. Griswold versus Connecticut is not a required court case. It's an interesting case, though. Connecticut had a law that basically said that doctors could not discuss contraception with married couples. And a married couple sued the Griswolds and basically said, how is that any of the government's business? And then the Supreme Court looked at the Bill of Rights and they said, yeah, you know what? That, this Third Amendment suggests privacy, the Fourth Amendment suggests privacy, the Fifth Amendment suggests privacy, and then throw the Ninth Amendment in there as well, which says basically just because we've listed these rights doesn't mean you have others. We think there's a right to privacy in the Bill of Rights. Therefore, Connecticut's law that prohibits a doctor from talking to married couples about contraception is in violation of the Bill of Rights, and therefore there's this right to privacy applies to the states, and then they're going to use that legal precedent of a right to privacy to suggest that a woman's reproductive rights is a private matter, again, between her and her doctor, and that is going to basically strike down all those state laws that existed prior to Roe v. Wade, which said you basically couldn't get an abortion in that first trimester. All right, so I just wanted to review that. Again, I'm going to get through everything civil rights tomorrow. It's going to be a lot. It's going to be a big video. You don't have to do it tomorrow, okay? Because I really can't give you new content. You can just go do it Monday if you want. I just think some of you guys most likely will jump on it, get it done. And then I'm going to put the MLK letter from Birmingham jail video up as well for you to review. Again, that doesn't have to be done tomorrow. It does need to get done. It needs to get done by Monday. I'm just going to make it available tomorrow. So for those of you that want to go ahead and wrap up the course so you can start your preparation for the AP exam, can go ahead and do that. Starting Monday, I'm going to start putting videos out that I go back and I cover all of the concepts from Unit 1, all of the concepts from Unit 2, all of the concepts from Unit 3. All right, so that's it for today. Go watch the Gideon versus Wainwright and case brief that. Again, really simple case. And then take a look at what I got tomorrow. Don't forget that you got your FRQ 3.4 due tomorrow as well.